Thank you for joining, everyone. We'll get started in a moment, but before we begin, I wanted to share some important housekeeping notes. Please note that we are recording this event. For our guests, we encourage you to use the Q&A feature to share your questions or comments. Now I will turn it over to Maria Prati.
Welcome to the Prytanian Homecoming Lecture. My name is Maria Prati, and I am president of the alumni of the Prytanian Women's Honor Society. Every homecoming, the society facilitates a lecture showcasing one of the past Prytanian faculty award winners. This year's lecturer is Professor of Law Andrea Roth, the 2017 Prytanian Faculty Award winner. Professor Roth studies how new discoveries in science affect the showing of evidence in criminal trials. For example, she has researched how new scientific discoveries about DNA should impact evidentiary proof. Professor Roth graduated from Yale Law School in 1998. She was a judicial law clerk for a Supreme Court justice in Alaska. She earned both a bachelor's in science and a bachelor's of art, one in mathematics and one in political science from the University of New Mexico. She was a Gray Fellow at Stanford University. She has published in many academic journals, among them the California Law Review, the Yale Law Journal, and the Georgetown Law Journal. She received the Cal Distinguished Teaching Award in 2019, and in 2016, she received the Berkeley Rutter Award for Teaching Excellence. Today, Professor Roth will speak on how the coronavirus is affecting the criminal courts. Welcome, Professor Roth.
Thank you. Thank you, Maria, and thank you to the Homecoming and Parents Weekend Committee for giving me the opportunity to speak to you. I'm really excited and especially proud as a Prytanian member to be doing the Prytanian lecture this year. So let me share my screen and see if this, make sure this works. All right, so I'll assume that we're good unless I hear otherwise, but so
you are good.
Great, so let me set the stage and then I'll try to make sure that we have some time for questions and answers at the end. What I'd like to just give you a sense of is, first of all, is this a crisis? And if so, is it unprecedented? This isn't the first epidemic we've had in the US that has disrupted criminal court proceedings. And then I'm going to go through the criminal process from beginning to end to give you a sense of how the typical way of things has been disrupted by the epidemic. In some ways that have silver linings. So pretrial detention, the right to a speedy and public trial, juries, both grand juries and trial juries, trial procedures, the taking of testimony from witnesses, and the physical layout of the courtroom and how that's changed, and then some lessons for the future and some implications for how we go forward from here. So first, on whether this is an unprecedented crisis and whether it's a crisis. The norms that we have for court proceedings are important not only because they are seen as important to accuracy, making sure that we don't have wrongful convictions or wrongful acquittals, but also to the appearance of justice. The public expects that we will decide cases in the court system in a particular way. And if they're decided in a way that people don't see as legitimate, that has a real impact on the rule of law. And so it's not just about accuracy, but it's about the appearance of justice and the integrity of the system as well. So is this unprecedented? Well, in 1918, this is an example of what they were doing in San Francisco. They, during the flu epidemic of 1918, you saw court proceedings happening outside and such. So the court proceedings were disrupted and there were creative solutions to them. But it was on a scale that was not nearly what we're seeing today. And there are a few reasons for that that I don't think would be obvious to somebody who hadn't gone through law school. So let me just explain some of the reasons that what we're seeing now is truly unprecedented. One is just the scope of the court system and the number of cases that we have now. In particular, in criminal cases, you've probably heard the public discourse now about the concept of mass incarceration, and that we do have rates of imprisonment in this country that are completely unprecedented, both for the country and also for the world outside of a few countries like China. And so there are a few reasons for that that we probably don't have time to get into right now, but the point is that it's undisputed that the levels of incarceration and the levels of criminal cases going forward being prosecuted are unprecedented. Just to give you a sense, the total incoming caseload in state courts in 2018 was 80 million. Now that includes civil cases, but even criminal cases and juvenile delinquency cases, we're talking about nearly 20 million state cases per year, and that's not including federal cases. There are over 4,000 federal crimes on the books now, not including the 300,000 federal crimes in administrative regulations. So the size of the system alone is just so different from what it was in 1918. We also have very different trial proceedings and rights for the accused than we had in 1918. So this is Earl Warren, was Chief Justice of the US Supreme Court during the 1960s, the so-called Warren Revolution in criminal procedure rights. He is a Berkeley Law grad, governor of California, former district attorney of Alameda County. But for these purposes, the reason that I put his other than he's, could be at alumni weekend if he were alive today, is that his court revolution, the many cases from the 1960s that you've probably heard about, like Miranda, changed the way that trials were conducted in state courts. And a lot of the constitutional rights that a criminal defendant has, the right to a jury trial, for example, before the 1960s, those didn't apply in state court. And so not until the late 1960s did you have a constitutional right to a jury trial in state courts. So now there are a lot of procedures in state courts that have to go a certain way constitutionally and create a lot of dilemmas in a pandemic that just didn't exist in 1918 because you just didn't have those rights in state court. Here's an article from late 1918 in a Georgia state court showing that, a lot of these issues like the right to a public trial were live issues even back in 1918. You had spectators basically being told to get out, but the right to a public trial at the time was not seen as binding in state court. So again, it was seen as okay to tell everybody to file out. Okay, and of course, we also have new challenges and new opportunities because there are technological solutions besides merely having proceedings outside. We can now have lectures like this and court proceedings remotely on Zoom. And because of that, we get to ask ourselves for the first time, should we have court proceedings on Zoom? And that just wasn't even an option in 1918. So new crises, new challenges, new potential opportunities. Okay, so let me start going through the criminal process and give you a sense of how things were and how things have changed because of the pandemic. So in the United States, in most jurisdictions, we either have, the state can detain people in jail before their trial. And in many states like California, we have something called a money bail system, which forces somebody, depending on what crime they're charged with, to put up a certain amount of money to make sure that they show up for trial, essentially. And then in other jurisdictions, like the federal government, we have a dangerousness-based system for deciding who is going to be detained before trial. But since the pandemic has begun, the question of who should be detained in jails before trial has become more fraught because of the levels of infection of people who are incarcerated in prisons and jails. You've probably seen the headlines about the huge numbers of cases from Santa Rita jail to San Quentin, I mean, all over the country, but in California, those in particular have made the news. So one argument is that we should just be detaining fewer people. We should be erring on the side of letting more people out before trial. And of course, you know, there are also more issues with compassionate release after somebody has been convicted. But I'm focusing now on the pretrial aspect of it. So there's two questions here. Number one, should we be reducing the number of people that we're putting in jails, keeping more people out, putting them on electronic monitoring or whatnot? And second, if we do decide that there are some people we should be potentially detaining, is it okay to make that decision in a virtual hearing where a person doesn't get a chance to make their argument for release face to face with the judge? So just to give you a sense of how things have changed, this was the original bail schedule in Alameda County before the pandemic hit. And on the right-hand side, you can see the amount that you have to put up for various felonies. So if you're charged with first-degree burglary, then you have to put up $50,000. And of course, lots of people don't have $50,000. What they can do is pay 10% to a bail bonds agency. And then the bond agency will put up the rest of the money, and then we'll come after you if you don't show up to trial. But you still have to put up $5,000. And the concern there is that a lot of people who are poor can't afford the bail, and so are incarcerated before trial, not so much because they're dangerous, but because they're poor. And so that's the big concern. The bail reform movement is on the ballot in California in 2020 yet again. But here's what the court did here in California. Back in April, they actually set on what's called an emergency bail schedule and changed all those amounts for low-level felonies and misdemeanors to zero, which let a lot more people out in California pre-trial. So it was a bit of an experiment. And there's been a dispute as to what the result has been. Some have said that crime rates, even with all of these new folks being released before trial, that crime rates haven't gone up. And so it's a complete success, and it's a sign that in the future, we now know that we were detaining too many people before trial. There are others who claim that crime rates have gone up. Just to show what the social cost is on the other side of the ledger, other than all of the concerns about people losing jobs and being more likely to be wrongfully convicted if they're detained before trial, you know, and that jail is tends to breed crime as well. We call it criminogenic, like carcinogenic. But also it just costs money, just regular old money to detain people before trial. And so if there is a way to detain fewer people, all other things being equal, presumably we'd want to do it. The LA Police Department claimed that the zero bail schedule did lead to an increase in repeat offenders. I'm not going to resolve that factual dispute now, but I just wanted you to see that dispute exists, and that it'll be an interesting question what lessons we draw from this experiment. In terms of the federal system, where people are detained not based on money bail, but based on whether a judge decides that they are dangerous. Okay, let's see. Now it looks like someone says they can only see part of my screen. I'm not sure why that would be. Let's see.
You go ahead and keep going and we'll work on that.
Okay, great. So the CARES Act, the Federal CARES Act, which was passed earlier in the spring, made a lot of criminal justice proceedings virtual. And one of them was pretrial detention proceedings, which arguably is a good thing. It makes it easier for everyone and safer for everyone. One concern is that there are some studies that suggest that when a judge doesn't see a defendant face to face and instead is making a decision about their detention over Zoom or over video, they're more likely to be detained. It's harder for them to argue that they should be released. And so here's one example of one of these studies. Trial by Skype, a causality-oriented replication exploring the use of remote video adjudication in immigration removal proceedings. They found that immigrants are more likely to be deemed removable and deported from the country if the decision is made over video. Okay, so that's one concern about the fairness of doing things over video if we decide to detain people before trial. So I'm going to move on to the public, the right to a public trial. I have a Mac, and my window in my, I can't tell if you're talking to the guest or to me, but I think
She's talking to the guest.
Oh, great. Okay,
Yeah.
wonderful. All right,
Yeah.
I'm going to keep going then.
Yeah.
So the right to a public trial is in the 6th Amendment to the U.S. Constitution. It's right in there saying that the accused has a right to a public trial. Why do we have a right to a public trial? To make sure that there is some public scrutiny of the process, so that if something unfair is happening to the accused, there's journalists there or family members or members of the public to see what's happening. Or on the other hand, if the prosecution is being too lenient on a defendant, if there's a plea bargain that just doesn't reflect what the community would want to have happen in the case, then there's public scrutiny of that as well. On the other hand, the right to a public trial is also an important right of the people. It's a First Amendment access right of the public and the press to see proceedings, to make sure that they're going the way that the community wants them to go. California Constitution also says that meetings of public bodies shall be open to public scrutiny. So what happens when we no longer have the same amount of in-person proceedings that we do? There are a lot of courthouses that even now in October are open to public access, but it's still only a few people who are allowed in each courtroom, and lots of people are unable to travel to courthouses or feel that it's unsafe, even if they could do it. So the technological efficiency and effectiveness of audio and video technology is critical to the right to a public trial. The right isn't absolute. Exceptions can be justified by a compelling interest if they're narrowly tailored. So for example, in juvenile proceedings where kids have a right not to have their names thrown about in the press, those are not public. Those proceedings aren't public. But otherwise, it's not something that can be easily thrown away. So here's an example of what some jurisdictions have done. Texas has an actual YouTube channel where any member of the public, including somebody in California, can just go there and go to a channel of a particular courtroom and just start watching. So it's really the first time in US history since the big, live court TV phenomenon started in the 1980s. This is the next big wave of potential national public access to proceedings. In some ways, that's great. You can do comparative studies. You can see what's going on in courtrooms around the country. It's so much easier for family members to watch court. Everything in some ways becomes so much easier. But there are also privacy concerns. Some victims advocates have said, look, these folks, victims and witnesses, didn't sign up, even defendants, didn't sign up to have their case broadcast to the entire world. There's a natural limit when something's in a courthouse and you have to actually go to the courthouse. There's a natural limit to the number of people who are going to be sticking their nose in your case. And, just like social media broadcasts everything you say to the whole world, it may be that there's a blow to privacy in having mass public access to proceedings. On the other hand, it's hard to deny that this is really nice, for example, for appeals proceedings. There was a recent Kansas Supreme Court hearing earlier in the spring that had 3,500 people watching, whereas normally you'd have maybe 100 people in the courtroom at most. And so here's what one of the a partner at the big law firm, Paul Weiss in DC, said there are currently over 3,500 people watching on a Saturday morning, many times more than could have fit in the courtroom. Kansas is a huge state. Most of those watching probably couldn't have made it to Topeka even under normal circumstances. So in some ways, this is just a beautiful thing for engaging the public in these proceedings in a new way. In the same way that we can all watch Amy Coney Barrett's confirmation hearings, we can all watch the Kansas Supreme Court or the US Supreme Court if we want to, in a way that's new. Okay, so just want to talk a bit about juries. Under the Fifth Amendment to the Constitution, in federal court, you have a right to something called an indictment, which is a decision by a group of people called a grand jury, between 16 and 23 people typically, that there is enough evidence for your case to go forward. It's a very low bar. It's meant to just make sure that a prosecution of someone is not just politically motivated or arbitrary. The framers thought that it was, the framers of the Constitution, James Madison and such, thought that this was important. Grand juries had a historical role as being a check on state power, but you don't have a right to indictment in state court unless the state decides that you should. The Fifth Amendment right to indictment doesn't apply in state court. So in California, for example, most state criminal cases are not indicted by grand juries. They just don't ever see a grand jury. So this is what it says. No person shall be held to answer for a capital or otherwise infamous crime, that means a felony, unless on a presentment or indictment of a grand jury. So why do I mention this? Because in some states there is a right to a grand jury, like in New York, for example, and in Kentucky, and the grand jury normally looks like this, with a lot of people right next to each other. And so what you've seen after the pandemic is that, because grand juries are a lot easier than trials to convene. It's basically these people, a prosecutor, a court reporter, and a witness in a room. There's no judge, there's no defense attorney. And so it's easier to do it online. And we don't worry quite as much if somebody has to use the restroom or, if their pet comes in and says hi, or even if they have to check their phone quickly. This is a recent Wall Street Journal headline. COVID's no excuse for grand jury duty when you can serve from your bedroom. So in some ways, this is making the grand jury process potentially more open and inclusive and efficient, and making the people who serve on the grand jury more diverse. And that is a great thing. That's a great thing. We want diverse jury pools. We want the entirety of the community to both have the obligation and the opportunity to be involved in jury service, because the right to a jury trial ultimately is trying to embody the idea that criminal law involves decisions by the community. And so it's critical that we are all a part of that. Okay, I'll talk about trial juries in a minute. That's really one of the hard parts. But I first want to talk about the right to a speedy trial, which is also in the US Constitution and applies in state court. The Sixth Amendment to the Constitution right there says the words speedy trial. You have a right to a speedy trial. And in most states, there's an actual law on the books that also says that you have a right to a speedy trial, actually in all states. But what does that mean? Is a speedy trial, does that mean you have a right to be tried within 6 months? No, there's no bright line rule. The Supreme Court has come up with a multi-factored, one might say, mushy test for deciding whether your right to a speedy trial is violated. And, there are some problems with enforcing this right, even when there isn't a pandemic. Judges can extend the time so long as there's a good reason to do so. And so after September 11th, after Hurricane Katrina, after Hurricane Sandy, you saw speedy trial claims being denied because they said, look, we don't have a choice. This is totally in the interest of justice that we wait a while before we have trials. The remedy for a violation is also very severe. If you don't get a speedy trial, if you have to wait too long, then the remedy is for you to just be released, for your case to be dismissed. So what if you're accused of multiple murders? It's a big deal to dismiss that person's case. And so courts don't lightly like to find a violation of the right to a speedy trial because the stakes are so high. The other thing is that criminal defendants often want delay. Sometimes there's a reason that they want some time to pass before their case is tried, or they have some investigation to do. But if they are held in jail before trial, it can be incredibly important for them to get a resolution of their case as soon as possible. And of course, victims and witnesses also want closure. So there's important rights at stake on all sides of this. And there's also a limit. So you do once in a while see that a court will say, yeah, we need to go forward on this. There's no choice. I talked to a prosecutor in Oregon, Multnomah County, who said that, there the right to a speedy trial is a little bit more of a bright line. You've really got to go forward after 3 months or so. And so they, I think it's no coincidence that Oregon was sort of at the forefront in the country of getting in-person jury trials started more quickly than other places. And I think it was in part because they take the right to speedy trial, I don't want to say more seriously, but they have a more bright line way of thinking about it. Okay, let's talk about trial juries. You have a right, a constitutional right to a jury trial in all serious cases. And, one thing that I have really been heartened by in this pandemic is the extent to which, from all reports, jurors are showing up and caring very deeply about their jury service, even during the pandemic. And you saw this in 1918 as well. Jurors voting to hold trial despite the flu epidemic. And you're seeing the exact same thing today. And so I think that it's a sign that when people are asked to step up, they do step up. They rise to the level of the expectations placed on them. And, this was a Zoom civil trial. I don't think that we can have Zoom criminal trials unless all the parties consent. One thing that we've learned from this is that you don't always need face-to-face proceedings. Sometimes we shouldn't have them. But one of the things that seems to be incredibly important for the appearance of justice and public legitimacy is to have criminal jury trials in an actual courtroom with people actually there seeing witnesses testify in person. And that's going to be really hard to get around. The main problem is that you've got to space everybody out in the courtrooms. They've come up with some pretty interesting solutions. Like in Montana, they're using big gymnasiums to do jury selection, for example. In Minnesota, they've put all this plexiglass in between jurors. So they, the human ingenuity in trying to figure out safe ways to have jurors in the same room is really showing through. Still, there's a concern about who is able to show up for jury service when we have it in person. It's even when we have it on Zoom, not everybody has internet access, but at least that can be remedied somewhat. But not everybody can make it to the courthouse and feel comfortable showing up for jury service. And so there's been some concern that the constitutional right to have a fair cross-section of the community on your jury could be jeopardized during the pandemic. And this is one of the key challenges to criminal proceedings during the pandemic, is that all of these rights that we've been talking about, they sometimes are contradicting each other, or they're butting up against each other. So for example, I really want a speedy trial. I really want to get this thing going because I think I'm wrongly accused and I'm detained before trial. I want to get this over with as soon as possible. At the same time, if I go forward now before there's a vaccine, then I won't get a fair cross-section of the community on my jury, because too many people of certain demographics or certain life experiences or conditions won't be able to come to the courthouse to serve, or won't feel the ability to do so at the same rate. And so if I go forward now, I get my speedy trial, but I don't get my fair cross-section. So it's been a real challenge trying to figure out how we get all of these rights at the same time to be satisfied. All right. Another a right that you have during trial is the right, and by you I mean criminally accused, is the right to be confronted by the witnesses against you. And so this is guaranteed by the Sixth Amendment, and it applies in both federal and state court. And it consists essentially of the right to physically confront someone and cross-examine them at trial and place them under oath. So the Anglo-American system of criminal procedure puts a premium on live, so-called live in-person testimony. Other systems around the world don't. They sometimes even prefer written testimony. So this is a culturally contingent idea for sure. But we, for better or for worse, our system loves live testimony. Well, that's all fine and good, but what happens during a pandemic? Well, we already have some Supreme Court cases that deal with these types of issues. So for example, we've had cases come up in the past where a victim in a child abuse case or a sexual assault case doesn't want to testify in front of the person whom they've accused because it would be overly traumatic. And so they've been allowed to testify via closed circuit television, as long as the judge makes individualized findings that forcing them to look someone in the eye would be traumatic. You have people who, for religious reasons, have said that, they cannot show their face while they testify. And so we've actually had situations where witnesses have had a face covering, and there's been seen their First Amendment right to religious freedom is butting up against the defendant's Sixth Amendment right of confrontation. So it's already not seen as an absolute right. But there's a big dispute about how far you can go in this sense. Justice Antonin Scalia, who's now deceased, but when he was on the court, he was a big fan of live in-person confrontation. And he didn't think that it was ever okay to let somebody testify behind a screen or via closed circuit television, however traumatizing it would be. And one of the quotes that he had in one of these cases that I feel like he would be screaming from the rooftops today is, "Virtual confrontation might be sufficient to protect virtual rights. I doubt whether it's sufficient to protect real ones." So there are some people who say this is an absolute right, and too bad, you just can't do it through a screen or a face covering or Zoom. Well, we have now some creative solutions to this. This is a judge in San Francisco pointing out that they're going to distribute clear masks to jurors and witnesses. Why clear? So that you can see their demeanor. So, one question is, why do we even have this right to confrontation? Well, one is so that you can question the witness and hear their answers on cross-examination. But the other is so that the defendant has the ability to look someone in the eye when they're accusing them, because the idea is someone is less likely to falsely accuse you if they have to look you in the eye and say what they're going to say. And another reason is so that the jurors can see the witness's demeanor, so that they can see whether they have sweaty palms or, shifty eyes, or they're not looking up. A lot of this is really culturally contingent as well. There are some witnesses who, because of their background, don't think that it's polite to look someone directly in the eyes. So, all of this is very, again, culturally determined. But this is one of the reasons that our system historically has put such a premium on live in-court testimony. So clear masks are going to have to be the way to go. I spoke to an Alameda County trial court judge recently, who's doing jury trials. And she had to actually, and this is sort of the creative ingenuity that our judicial officers are showing, she had to buy a bunch of face shields on Amazon for the witnesses and court personnel in her courtroom, because the system just hadn't gotten around to giving them out. And so you're really having these, ad hoc solutions, courtroom by courtroom. So yes, the face mask, when it's clear, the concern might be that they also have to be safe. A lot of the clear face masks aren't seen as safe, but assuming that they're safe, that's going to have to be the way it goes for witnesses. And of course, now they've got plexiglass around the witness box and all of these ways to make sure that the jury can see the witness. The problem is, in a physically distanced, socially distanced courtroom, the jurors, instead of being 5 feet away from the witness, getting to see the beads of sweat on their forehead when they're lying on the witness stand, they are more like 20 or 30 feet away. And it's very, very different to be that far away from a witness and try to look at their demeanor. And so you're seeing defense lawyers argue that the courtroom procedures that have been set up, however well-intended, just aren't good enough to guarantee the right of confrontation. So this is something that we don't have an answer to yet. This is being litigated every day in criminal courts around the country. This is one of my research interests, actually. I've been thinking for a long time about machines and the fact that in a lot of criminal cases now, the primary witness against you is not even necessarily a person, but a machine that spits out your blood alcohol level, or a machine that says that, this note was written by you, or a machine that says that you are a contributor to this DNA mixture. And some of these computer programs are incredibly complicated, involve machine learning, and they can't be placed under oath. They can't be physically confronted. Maybe you can cross-examine an android on Star Trek, but you can't cross-examine a computer program in 2020. So what does it mean to be confronted with the witnesses against you when a witness is a machine? And that's sort of what I write on. And so there are ways that you can scrutinize the testimony of a machine. It wouldn't be cross-examination, but it might be looking at other statements that the machine has made. It might be, viewing the source code of the machine, subjecting it to independent software testing, lots of things that one of the things I'm working on now is suggesting that we could do the same thing with people. And so here we are in a pandemic where our ability to physically confront witnesses is somewhat being jeopardized. But we've got all these other things we could do. We could find out the prior witness statements of the person on the witness stand. Let's see what they've said before on the same subject matter. An eyewitness, we can look at what the eyewitness procedures looked like, whether the photo array was fair. We can, with expert witnesses, we can look at what their proficiency testing results were. None of these right now is guaranteed under the Sixth Amendment, and I think that we should rethink what confrontation means with respect to human witnesses, and this pandemic is a really nice opportunity to do that. So stay tuned. I'm sure, as I joke, law review articles don't have a huge readership. My parents are pretty much maybe the only ones who will read this article, but who knows? And the Supreme Court has said that, you know, the mission of the Confrontation Clause is to advance a practical concern for the accuracy of the truth-determining process in criminal trials by assuring that the trier of fact, that's the jury, has a satisfactory basis for evaluating the truth of the testimony. So, you know, the Sixth Amendment says confrontation. It doesn't say beads of sweat or cross-examination. And so I think that we need to take a broader view of it and do whatever we need to do to make sure that the government's evidence is properly scrutinized in whatever form. All right, right to be present and to consult with counsel. So defendants need to talk to their lawyers. They have a right to a lawyer in any case where they actually end up being incarcerated. And it's important to be able to talk to your lawyer. And usually, pre-pandemic, you're able to confer with them face to face and have your lawyer, you know, put their hand on your back and whisper in your ear during trial and all of this. Over Zoom, that's not possible. And even in the jail, that's not possible. My husband is a federal public defender, and you know, he's now got a dedicated work cell phone that he's been given, and clients call him all day and even night from the jail, collect calls, and he hasn't been able to meet in person with a client for a while, except for those few proceedings that are still in court and in person. So it's been very challenging to have that same level of intimacy between a criminal defendant and their lawyer during the pandemic. At the same time, it's easier to call someone on the phone and have several phone calls in a week than it is to, you know, make the 15-mile trek out to the jail and see the person. So in some ways you can talk more frequently with your clients, but not as intimately. Let me say just for a minute some silver linings, and then I want to just leave you with one thought and then open it up for Q&A. So we've talked a little bit about some of the challenges and the constitutional norms that are potentially jeopardized during a pandemic. But there are some things that I think we've been pleasantly surprised by that we should keep after all of this subsides. And by subsides, I don't mean ends. You know, this is definitely the new normal. But one of the things that this allows us to do is to have a natural experiment with a bit of decarceration. You know, we get to see whether jailing fewer people before trial has a crime rate associated with it that we can handle, especially given how much money we would be saving in the process. And so this is kind of a nice way to force ourselves to at least experiment with a lower level of incarceration. It's so much easier in many ways for the public, for defendants, for victims, for witnesses and families to attend court. And court doesn't just mean trials. There are so many little status hearings that defendants who have jobs and victims and witnesses who have jobs have to try to take time off work just to go to a 9 a.m. court proceeding just to find out when their trial date is. And it's become a little ridiculous and potentially jeopardizing, especially for low-income communities. And so it's in some ways a lovely thing that we now have been forced to have the technological capabilities to have some of these lesser proceedings online for everybody's benefit. And better grand jury response rates, if we can do them online, and recognizing other ways to scrutinize witnesses, again, beyond live questioning. See Roth's forthcoming article. Okay, last slide, just some lessons for the future. The first is that I think this is the new normal. Even if we get a vaccine, we'll be, you know, getting shots every year, or whatever this works, we will have we'll have more pandemics, we'll have more natural disasters that make it difficult to travel. This is something that we need to get used to, and I think we are developing slowly the infrastructure to do that. not all proceedings need to be or should be in person, but some do. So we're really being forced to think hard about when being in person matters. We've been forced to do that with the classroom as well, and with our friends and family. We're starting to see where being at home is lovely and where the lack of in-person social interaction is can be, soul crushing over time. And one final lesson, which is, this whole concept of what is a live proceeding versus a remote proceeding is itself potentially artificial. So, there's a scholar at McGill University, Jonathan Stern, who's written this book, The Audible Past. And his point is that the whole concept of live music wasn't even a concept, wasn't even a thing until the 1950s, when recordings started to be more commonplace, and performers who were in unions wanted to make sure that they still had the ability to give live performances. And so there's been a lot written about the concept of live music versus recorded music, and the fact that both of them are actually mediated experiences, and that there's no such thing as pure live music. You're always in the audience, and there's something between you and the performer. Well, same thing with trials. So-called live and so-called remote court proceedings are both mediated experiences with their own set of artifacts. So in some ways, having a jury, in some ways, this lecture is potentially more, we're allowed to have more people here than if we were in person. It's potentially more intimate because you can perhaps even see me better or see my slides better. You can go back and forth. You could be sipping coffee while you're listening to me. There's lots of artifacts of this as compared to being in a lecture hall that could be good or bad, but they're both mediated. Then they're both remote in certain ways. So the courtroom isn't any different. And so I don't think we should fetishize the idea of a live trial. I think that we should just recognize that there are benefits and costs to being in a courtroom versus being over Zoom, versus being over the phone, and decide which proceedings should be done in which ways accordingly. And this is Nick Matthew, who is a celebrated professor in the music department. He's the one who I have to give him and the Berklee Podcast for Music, which he developed and runs, credit for cluing me into Professor Stern's book, The Audible Past, and this whole concept of live versus recorded music. And it's really opened up my eyes to thinking about the courtroom in a different way too. Okay, so I'm gonna stop there, and hopefully we have time for a few questions. Otherwise, I can just talk until I'm blue in the face. That's what trial lawyers and professors do. So
thank you, Professor Roth. I don't see any questions. If anyone has any questions, please place them in the Q&A. I actually do have a question myself, which is, when you were talking about your work around sort of confronting a machine as a witness, do you think there's a perception that machines are somehow not fallible in a way that human witnesses might be?
Yes, absolutely. So thanks for that question. I think that is the main concern with machine testimony, is not that they are in general less reliable than humans. In some ways, it's such a beautiful improvement to have a computer program decide your blood alcohol level rather than a police officer who just decides subjectively whether you're impaired off the side of the road. But the problem is if jurors think that it's more reliable than it is. I mean, we have that problem with human witnesses too. If they see somebody in a white lab coat, they think, oh, well, that person must know what they're talking about. So this isn't just something that arises with machines, but I definitely think that humans sometimes have a sense that machines are either this complex steel box that's not to be trusted, which is also fallacious, or It's this, beautiful, perfect, objective thing that's to be trusted. Um, whatever it says is gospel. So I think that's precisely why it's so important to ensure that we have some way of scrutinizing the processes that go into it, and having more, not that transparency is always, full transparency is always, it's not always possible, it's not always a good thing, but we need more transparency with respect to some of these computer programs that right now are deemed trade secrets by companies who, jealously guard them as proprietary and won't allow anybody to see inside the black box.
Good, interesting talk, and we're getting a lot of good reactions, and we have some questions. So one is, I recall that some court trials were conducted in communist countries that were not live. Am I recollecting correctly?
So currently or back in the day, I wonder. It's definitely the case that in various countries, this concept of live testimony just has not been a thing. In Mexico, until very recently, they actually had a preference for written testimony. And it's only recently that they've sort of used the American system as a template. So, I certainly wouldn't be surprised, though, because the whole concept of, accusation behind closed doors, if you are an oppressive regime that doesn't want to be scrutinized and wants to imprison your political opponents, then you don't want transparency. So, yeah, and that's one reason we have the right to public trial, to stop that from happening. In some ways, though, having remote proceedings, as long as the public is allowed to watch them, would increase transparency even beyond what we had pre-pandemic. So no, I'll look more into what's been going on and in communist countries in their proceedings.
Great. How about this question? Given that this is the new normal, have you come up with a list of safe practices and or ways to make sure that attorneys are making a full and complete record?
Yeah, well, I think that there are some courts, including Alameda County, that it sounds like are doing wonderful things, when it comes to trying to find a way to actually have at least 2 courtrooms in the courthouse that are having criminal jury trials. I think that, the problem might be the distance between the jurors and the witness. So if there's some way to further figure that out through technology, that would be a good thing too. So it's not that there aren't things to be tweaked, but I think we're getting close to figuring a way to safely have in-person jury trials, at least some. And, I think this is my own view. I think the system was too bloated before the pandemic. And so, one thing this might do is to force us to have fewer prosecutions of low-level offenses and to focus on the things that really matter. And if we do that, there will be fewer proceedings that we need to have. There will be fewer trials that we need to have. And so it could be that it works itself out, that we don't have as many courtrooms as we used to be able to have for certain proceedings. In terms of attorneys making a record, there are some great, listservs and opportunities for attorneys to talk to each other, in part because of technology. And, there's template motions being distributed for making objections based on the confrontation clause to witnesses who are wearing masks and such. But the appeals courts are going to have to deal with a lot of these issues related to speedy trial and things like that. And so unfortunately, it's sort of a wait and see thing. But I think attorneys do have, most criminal defense attorneys are on listservs and such that that make those available. The larger problem is that criminal defense attorneys do not have access to expert witnesses and the ability to scrutinize machine testimony or forensic evidence and get alternative testing and experts. So that's the problem, more so than being able to object to witnesses who are wearing masks.
We had a question about how the courts are handling high risk people. Is there anything that they are doing to protect those people in particular who might be incarcerated?
Yeah, I mean, I know in the prisons and jails, they are attempting to, compartmentalize the populations, and with varying levels of success. For very few proceedings are defendants brought to the courthouse. Really in-person sentencings and trials are the main priorities in terms of not having it done remotely. But this is all with the defendant's consent. It's really the defendants themselves who are consenting to have remote proceedings other than, sentencings and trials. So yeah, they, it's not like, defendants who may well be infected are being brought to the courthouse in large numbers. On the other hand, there was a trial in the Northern District of California in federal court where at least one juror was tested positive after an in-person jury trial started. I don't know if they know absolutely that the juror was infected during the trial. It could have been a coincidence, but that happens with flus and colds now. I mean, the real question is going to be, is the risk associated with COVID low enough after a vaccine or after certain treatments, antivirals become more widespread, that this is a manageable illness. But we're never going to get to zero. Just like when you show up for jury trial, you could get a cold or the flu, and the flu could be fatal. So we're not going to go to zero risk ever for in-person proceedings with anything, just like with the subway. But we need to know what the risk is with respect to this disease before we go forward.
Here's a question about records. Do you think that the shift to remote or mediated trials will also shift more digital files within the law? The court system seems to rely a lot on paper and fax machines, especially here in the Bay Area. And the question related to that is, how will this affect record keeping?
Yeah, already multimedia has just, taken over the court system. Like even when I was practicing, like a trial lawyer 15 years ago, nobody ever used PowerPoint in their closing arguments. And now it's like malpractice not to use PowerPoint in court. So lots of things have changed in the courtroom that way. And same with files. I mean, discovery, when you get a DNA report now, it's electronic. And so, yeah, most everything is generally electronic. There's also new rules of evidence related to the authentication of electronically stored and generated evidence, and even e-discovery, electronic discovery, going through a bunch of files and searching for certain terms and things that are ongoing now. So yes, you're seeing a massive shift towards digitization, and litigants are responding accordingly. I think the main issue is just that it's increased the volume of information. And so, e-discovery techniques are becoming incredibly important so that litigants aren't overwhelmed with the amount of data that they're given.
Well, we're just about to wrap it up. There's one question that would be really quick to answer, which is, what was the name of the scholar who has questioned the construct of live versus recorded music?
Yeah. So I want to highlight my colleague, Nicholas Matthew in the music department. But the scholar is Jonathan Stern with an E at the end at McGill, who's a media studies person and wrote The Audible Past, which gets into a lot of this. And I think there's been others, before that, but that's a place to start.
Great. Well, thank you so much. And I think we're done unless anybody has a reason to say no. Forever hold your peace. All right. Well, thank you so much, Professor Roth. Thank you, everyone, for
Thank
joining
you.
us today.
Take care.
Thank you, Professor Roth.
Thank you.